Welcome, everybody. Thank you for joining us tonight for the discussion of Josh Douglas's latest book, The Court versus the Voter. And I have my copy here somewhere, but my desk, oh, here it is, under my desk, cluttered. So I have it here. The troubling story of how the Supreme Court has undermined voting rights. So this is very pertinent to the work that we do. I'm Jen Jackson. I'm president of the League of Women Voters of Kentucky, and many of you may know, but for those of you who may not be aware, the League of Women Voters of Kentucky is a nonpartisan grassroots organization. And while our name reflects our history, we welcome all that believe that democracy works best when everyone, including women, have a voice. I'm honored to introduce Professor Joshua A. Douglas, a distinguished member of the University of Kentucky's J. David Rosenberg College of Law, where he serves as the Ashland Spears Incorporated Distinguished Research Professor of Law. Professor Douglas specializes in election law and voting rights alongside civil procedure, constitutional law, and judicial decision-making. He is also the author of Vote for Us, How to Take Back Our Elections and Change the Future of Voting, a highly influential book offering hope and practical solutions for improving voting rights. Leagues across the country, including our own, have embraced that work as an inspiring roadmap for engaging with voters. And if you haven't read that book yet, I highly recommend that you pick it up and read that as well. Professor Douglas's latest legal scholarship delves into the constitutional right to vote, especially at the state level, and how laws, rules, and judicial decisions impact election administration. And before we continue, I'd just like to note that the views expressed by Professor Douglas are his own and do not necessarily reflect the views of the League of Women Voters. Tonight, we're here to discuss his latest book, The Court versus the Voters, the troubling story of how the Supreme Court has undermined voting rights. And with that, I'm delighted to turn things over to Professor Douglas.
Awesome. Thank you, Jen. And it's a delight to be here. It's a delight to have opportunity to connect with the League. See some familiar faces and names and some new friends. So it's all great to welcome many of you, or all of you. But some of you have been to my book talk about this book, right? So I don't want to just rehash everything that you've already heard. So I'll do, for those of you who were not at the book launch or otherwise, I'm happy to kind of go through some stuff about the book, but I'm also happy just to chat about what I've been working on recently, because this book was published in May and I'm always having new projects, or sort of the state of what I'm thinking about as we enter the election season, the things that are concerning me, the things that are exciting to me. So we can take this in whatever path that you want. Let me first start by, Jen noted, no bathroom breaks during the Zoom. You all may not realize, or some of you may know, but there's actually a somewhat famous toilet being flushed during a Supreme Court argument during the pandemic. That during oral argument, they had Zoom arguments, and I think someone managed to sleuth out and figure out it was Justice Breyer, who had forgotten to unmute and flush the toilet during the oral argument itself in a case. So we'll try to avoid that happening. The League is really important to me in terms of the advocacy that you all do and the work that I do. I have colleagues who write really important scholarship about 16th century Scandinavian theories of corporate law or whatever, and that's interesting, but I often wonder what the practical relevance is. And I've tried really hard in my work on voting rights and democracy to make sure that the practical is there as much as the theoretical, because I think that especially for this area, if we're not reaching out to people, voters who don't necessarily know all the details of what's going on with voting rights, then we're not doing all that can be done in protecting our democracy. So the League is really important to me in the way that it's embraced my work and has helped facilitate some of these things. Before I tell you a little bit about the book, I also wanted to mention something I have been working on recently, because it does involve the League a lot in some of the research, which is I'm writing about the history of voter registration and voter registration drives, and contrasting that with some of the laws we're seeing in places like Florida that are putting restrictions on third-party organizations in their voter registration efforts, and doing all these sorts of crazy things. And Missouri's got some, Kansas. Luckily, we've avoided this in Kentucky. We've had laws like limits on how many voter registration forms each individual volunteer can process, can receive. Compensation restrictions, and those are very broad to be things like, League of Women Voters chapters are not sure if they can buy pizza for their volunteers, because would that be considered compensation? And because the Supreme Court has been so focused on history and tradition in a lot of its rulings, and asking, does a practice that's being challenged, does that comport with what historically had occurred? I thought I would look at the history and tradition of voter registration. What I found was really fascinating, which is that since the beginning of when states have required voter registration, which is basically the late 1800s and early 1900s, the League, or the precursor to the League, the National NAWSA, I forget the exact acronym, but that was a precursor to the League, was involved in voter registration. Which I thought was really interesting, that basically from the very beginning of states saying we need to have an official list for the polls, it was the League that was involved in ensuring that people could get on the rolls. So my argument in this new article is that if the Supreme Court is actually serious about history and tradition, it's not just picking and choosing the history that it likes to reach a certain outcome, then a lot of these laws should be struck down. A lot of these laws that are imposing barriers on organizations in registering voters should be struck down, because they're contrary to the history and tradition of organizations like the League actually engaging in voter registration efforts. So I'm happy to talk more about that if you're interested. Like I said, that's kind of one of my research areas right now, an article that I am working on. But Jen asked me to talk about the book, so let me give a little bit of a brief overview. And again, apologies to some of you who have heard bits and pieces of this talk before, but I'll try to change things up a little bit as well. So maybe there's something new for everyone. So as Jen mentioned, I wrote this first book, which came out in 2019. It's called Vote for Us: How to Take Back Our Elections and Change the Future of Voting. And it's basically a good news book. It's a book about good news in the world of voting rights and elections. And when I tell people I wrote a book that's got good news about voting, they assume it's just one page long. There's not much there to say, people think. But actually, there's a whole book, right? It's a nice thick book about stories. It's really a book of stories of people, I call them democracy champions, all around the country that are helping to make the election process more convenient, more inclusive, and more democratic. And that also is still informing some of my recent work. Many of you know I started a podcast this year, a radio show and podcast called Democracy Optimist. It's running on WEKU right now every other week. And it is also on all podcast platforms. So you can find it on Spotify, or Apple, or wherever you get podcasts. And then literally today, I launched a Substack called Democracy Optimist. So you can go and find, just search Democracy Optimist Substack, and you can find that. And I basically plan to post, as we get closer and closer to election season, various good news stories about what's going on in the world of voting and elections. Because essentially, I feel like there's so much doom and gloom out there on voting rights. There's so many stories about various efforts to suppress voting. Right now, we're dealing with a lot of questions about whether states can fail to certify the results of an election. We're seeing news stories from Georgia about a new law that arguably might let local election officials slow down the certification process if they don't like the results in November. But there's a whole lot of good news out there. And I think we need to lean into those positive stories, because otherwise we're just going to throw up our hands and say, well, the system is rigged, and what can we do? And so Vote for Us was an effort to tell some good news about voting rights. The Democracy Optimist podcast, which Jen and a couple other League members have been on, we had an episode featuring the League, is an effort to explain kind of how things work. And then the Democracy Optimist Substack that I just published the first post today, again, or the introductory post basically, again, is going to be an effort to demonstrate some good news in voting rights. And actually, one of my research assistants, Jack Bissell, has been working with the League as well, and Jack's been really helpful in setting up that Substack. So a lot of synergies going on between the work I'm doing and what you all are doing. Okay, so that's all kind of a background of I'm an optimistic guy, even though I recognize there are some challenges, but I think it's better to be optimistic to understand what's possible. And then I wrote a book called The Court versus the Voters, the troubling story of how the Supreme Court has undermined voting rights, which does not sound all that optimistic. And it is not, because while I think of myself as an optimist, I also think of myself as, or at least I try to be a realist, to understand what the problems are. And that's, if we understand the problems, then we can get to a feeling of what's possible. But we need to understand that first. And the catalyst or the impetus for this book was after the 2019 book, Vote for Us, I kind of wanted to do the same thing again. It was fun to write a kind of good news story on voting rights. And so I sort of set out to kind of do the same thing and have another book that talked about what's possible, how we can get to compromise, how we can figure out, my own personal view, by the way, is that, if one side is determining the rules of the game for an election, that's not legitimate. That we need to have both sides come together to try to figure out, at least as best we can, compromise on voting rules. No one would think it's legitimate if, the referees in the UK versus U of L game were all Louisville fans, and they got to not only judge the game, but also come up with the rules for how the game would be played. And that's sort of how I see when one side dictates the rules for everyone. So I had this idea to write. It's going to be called The Grand Election Compromise. It was going to talk about principles for how we can come together on voting rights. And a trusted advisor, after I pitched the idea to her, basically said, that's great, but that should be your conclusion. You need to explain what the problems are, where there's a desperate need for people to understand. And she kind of proud of me. She said, well, why do we need a compromise? Isn't the Supreme Court just going to strike down the bad laws and tell us how things should be done? And I was like, you're real funny. The Supreme Court can't be trusted to do anything. And she was like, yeah, that's my point. You should write that. And so that's where it started to talk about how and why the Supreme Court has been harmful in the right to vote, in failing to protect the right to vote. Now, I think that in order to be able to have people who aren't lawyers understand this stuff, you need to tell stories. I think stories drive the narrative, make it interesting. And so as I like to say, the book is basically a book of stories, and then I sneak in a little bit of law here and there as I try to tell the story of why the Supreme Court has been harmful on voting rights. Now, again, a few of you have been at one of my book talks, either the book launch back at Pivot Brewing in May. I know at least one or two of you were at the Cincinnati talk, or Northern Kentucky talk in Covington. And I told some stories about from some of the chapters in the book. Each chapter is a different case, by the way. So some of the cases you've probably heard of, like Bush v. Gore, and I tell a little bit about the behind the scenes of Bush v. Gore, but also the implications of that case and how it's led to post-election disputes in virtually every election cycle since. Another case that many people will have heard of is Citizens United, about campaign finance. And I tell, again, the behind the scenes story of that case. I lead the chapter off actually with a story about a corporation called Murray Hill that ran for Congress. This guy who ran the company heard about the Citizens United case and said, wait, if corporations can spend money on elections. Why can't they run for office, et cetera? And so he actually filed nominating papers to run for Congress in Maryland as the corporation itself, which is obviously funny, but also trying to make a point. So there are cases that people have heard of, and then there's cases that no one's heard of, like in chapter 1, the case called Anderson versus Celebrezzi from 1983, which involved John Anderson's run for president as an independent in the 1980 election, and he was denied ballot access in 5 states. He sued. He ended up getting on the ballot, but the case took 3 years for a final resolution at the Supreme Court. And the outcome of that case, which Anderson actually won, isn't that important, but the test that the court set out, this idea that we're going to let states have some leeway in how they run elections, has, again, from 1983, laid the foundation for lesser protection of the right to vote. But again, I told the story during my book talks, my book launch, about chapter 2, which is a case called Burdick versus Takushi. This is about a guy named Alan Burdick in Hawaii who wanted to do write-in voting, and was unable to, went to his polling place, and they wouldn't allow him to write in a candidate instead of one of the ones listed on the ballot. And so he sued, and he brought the case all the way to the Supreme Court. People ask me what my favorite case is or favorite chapter from the book. I often point to that case in that chapter because I think it's really interesting. It's got murder, it's got Donald Duck, and it's got a really interesting, quirky guy from Hawaii that I managed to track down and interview all these years later, who had no idea that the case that bore his name is actually taught in virtually every law school that has a voting rights course in the country. Well, that said, I think I'll tell a different story today from another one of the chapters, because I know this is an issue that the League is focused on as well, which is felon disenfranchisement, or the practice of denying the right to vote to individuals convicted of a felony. And I'm asked all the time, why is it that if the right to vote is an important constitutional right, why is it that states rather are allowed to deny the right to vote to someone convicted of a felony? In fact, literally, I'm teaching this semester, I'm not teaching my election law course, I'm teaching constitutional law. So we're talking more broadly about issues of involving the Constitution. And I had a student come up to me today after class and literally asked this question: wait a second, why are we allowed to disenfranchise individuals convicted of a felony? I thought the right to vote was an important fundamental right. And the reason that states are allowed to do this comes from a case from 1974 called Richardson versus Ramirez. Again, it's a case basically no one's heard of before, but unless you've studied this issue, but is vitally important for the scope of the right to vote. So here's what happened. In the 1950s, this guy, Ramirez, was living in Texas, and he was at a restaurant, and he got into a bar fight. It's not entirely clear from the record that I could track down, and I spent time searching for him and his family. He had since died, but I was searching for his family. I went to the Library of Congress in DC and looked through all of the papers of the Supreme Court justices to try to find some tidbits about what happened. And as best I could piece together, he basically got into some sort of argument at a restaurant. He was in his early 20s, and as a restaurant / bar. And he got into a fight, was arrested for battery, essentially, and convicted, or I think he pleaded guilty, actually, and ended up serving about 9 months of jail time. So he gets out, he gets a job in Texas, and eventually decides to move to California, and is working as a farm laborer, essentially. He's working on a farm. And he's the named plaintiff in this case, Ramirez. There's 2 other plaintiffs as well that have kind of similar stories. This was people who had been convicted of a felony years before, had finished their sentence, and then were living as productive members of the community. Unlike that case from Hawaii, the guy Alan Burdick who wanted to write in a candidate in the Donald Duck case, and that was just someone who was kind of disgruntled by the way democracy was working and decided to sue. This case, Ramirez, about felon disenfranchisement, is what we refer to as cause litigation. That is, there were some lawyers, some organizations that saw an issue and decided to see if they could find the right plaintiffs. And so they put out a call in various communities. The lawyer's name is Marty Click. I was able to interview him for my book. So I got a lot of the background story of how this worked in terms of the litigation strategy. How are we going to go and challenge this law? And so they came up with a strategy. They wanted to challenge the California law. And the way the California law worked at the time basically was that it was up to each county whether they wanted to allow people with a felony conviction to vote or not. So it was different based on where you lived in the state, whether you were allowed to vote. And so they put out a call in various communities, mostly Latino communities, for plaintiffs, and found Ramirez and the two others. And what's sort of interesting, I think, also is that although the case bears his name, he basically did nothing in the case. I mean, he gave his name to it, but it was just the lawyers who did everything else. Because this was a simple challenge to the law in and of itself. And they had a lot of success in the lower courts. The California courts said, yeah, you can't have a regime where whether you're allowed to vote is based on which county you live in. And each county can decide for themselves whether to allow individuals with a felony conviction to participate in democracy or not. So they went to the California Supreme Court, and then it goes up to the US Supreme Court. And here's where things became problematic, because all of a sudden a brand new argument was introduced essentially at the US Supreme Court. And here we're going to have to get a little technical on the law, but I'll simplify it as much as possible. The argument is that denying some people the right to vote because of a felony conviction violates the Equal Protection Clause of the 14th Amendment. The Equal Protection Clause simply says states cannot deny equal protection of the laws. So you have to treat everyone equally. And so that was the basic argument. And this kind of makes sense, right? If you're saying some people can vote and others can't, and voting is a fundamental right, then that seems to deny this idea of equality. But there's another really obscure provision in section the 14th Amendment, and this is known as Section 2 of the 14th Amendment, and it's sometimes referred to as the Reduction in Representation Clause. And here's basically what it says. It says that if a state denies the right to vote to people, then it says to any male inhabitants, but now after the 19th Amendment, it's to anybody. If the state denies the right to vote to people, then the number of Congress members that state receives is reduced. So, but hypothetically, if Kentucky with 6 members of Congress, if it for whatever reason denies to people, 1/6 of the population denies the right to vote, then Congress could say, Kentucky, you don't have 6 members anymore, now you have 5. We're going to reduce your representation. And the whole point of this was in the aftermath of the Civil War. Those who wrote the 14th Amendment were concerned that Southern states would deny voting rights to newly freed slaves, right? And we had the 13th Amendment, which said you can't deny the right to vote based on the basis of race. Or excuse me, the 15th Amendment. 13th Amendment abolished slavery. The 15th Amendment, which says you can't deny the right to vote on the basis of race. But they also wanted to put something in the 14th Amendment that says if you deny the right to vote, we're going to take away your representation in Congress. That's why it's referred to as the Reduction in Representation Clause. You deny the right to vote, you get fewer members of Congress. Now, by the way, Congress has never actually invoked this clause, never used it, but it's there. However, the clause also says if you deny the right to vote, except for participation in rebellion or other crime. So it says, can't deny the right to vote or you lose representation. But if the reason you're denying the right to vote is because of participation in rebellion or other crime, then it's okay. Then we're not going to reduce your representation in Congress. And why did the framers of the 14th Amendment put that in? Well, they wanted to let Southern states deny the right to vote to the people who are in the Confederacy. Right? If you rebelled against the Union and you were, charged with treason, then we wanted to basically say it's okay to take away your right to vote in that instance. So can't deny the right to vote to people. If you do, you're going to lose representation in Congress. But if the reason you're denying the right to vote to these people is because of their participation in rebellion or, quote, other crime, then it's okay. So the argument that California made to the US Supreme Court when this case goes up to the court, which hadn't been discussed previously in the lower courts, was, well, the Constitution allows us to deny the right to vote to individuals convicted of a felony, because that clause, the 14th Amendment, Section 2, says you can't deny the right to vote, and can't deny the right to vote unless the reason you're denying the right to vote is because of rebellion or other crime. And the court buys this argument. It says, yeah, the 14th Amendment does allow, or at least contemplates, that states might deny the right to vote because of a so-called other crime, is the language in the Constitution. Now, I think this is totally backwards. The whole point of the 14th Amendment and this clause was not to let states disenfranchise individuals. It was to ensure that states were required to let people vote. But if they wanted to deny it to people from the Confederacy, well, okay, we understand that. But the court instead, in this 1974 case, expanded upon that hugely to say this gives an affirmative sanction to states to let them deny individuals the right to vote. The other problem is, even if you say, okay, it does have the language other crime, so maybe back in the late 1800s, when they wrote the 14th Amendment, they were thinking that states could deny voting rights to people involved in a other crime other than rebellion. The types of things that were crimes back then and the types of things that are crimes now are wholly disproportionate. Back then, you had basically what was considered the crimes in common law were things like murder, things like rape, things like treason. Now, you've got things like forgery is a felony. And so you can be denied the right to vote in a place like Florida, essentially for life, for passing a bad check. And so what those who wrote the 14th Amendment, which again was the response to the Civil War, intended, and what the court has allowed today, are totally out of whack. But ultimately, the answer to why is it constitutional to deny the right to vote to people convicted of a felony goes back to this Richardson versus Ramirez case. So it starts with a bar fight in the 1950s, ends with Ramirez losing this case because the court says states are allowed to do this. Now, the lawyer, Marty Glick, who brought this case, who I got to interview, says he won, actually. Now, he lost at the Supreme Court, but he says what the case did was it led to a movement in California to change California's laws. And about a year later, the voters did pass an amendment to California's rules that undid the severe felon disenfranchisement that existed in the state. Didn't take away entirely, but basically said it's much easier to regain your right to vote after you've served your time. So the case, if you're thinking about California in particular and the message it sent, it was an initial loss at the Supreme Court, but maybe a win in some ways for those voters because it brought the issue to the forefront. But the court has now used the case over and over again as precedent to say the 14th Amendment allows felon disenfranchisement. Again, I think that interpretation is wrong. Justice Thurgood Marshall, in dissent, thought the interpretation was wrong, but that's what it is. So that's just one of the stories from the book that highlights an important case that basically people have never heard of, most people have never heard of unless you've studied this issue, and explains the people behind it, the stories behind it, but also then the implications of the law behind it as well. Let me pause there, and I'm certainly happy to tell more stories from the book. We can pull out another case or another chapter. But let me just pause there first to see if there are any questions or specific topics that you'd like me to talk further about that I've mentioned so far.
Hi, this is Julie. I have a specific question, but I have a comment first. I think it's really interesting that you're not teaching a class in voting rights law this semester. I've been thinking about that the whole time.
Yeah, so I'll tell you why. So I actually was supposed to be on research leave this entire semester and not teaching, just getting to focus on my research. I've got a bunch of travel coming up to give talks, to do some additional research in various areas surrounding the election. Election season is always ridiculously busy for me.
I bet.
I'll probably never forget 2020 when we were had the pandemic, and my kids where the older one was starting a new school in 4th grade and the younger one was starting kindergarten. In the 4th grade, and my wife's a school teacher, so we had 4 Zoom classrooms going on at the same time in the house, essentially. The 4th grader was pretty much good to go as long as we got her computer, as long as her computer worked, which usually was fine. The kindergartner, though, one of us had to be with him pretty much all the time to make sure he was staying on task. And so my wife and I would trade off depending on what her class schedule was and my class schedule. I'll never forget responding to a New York Times reporter while making sure that Harrison was staying on task in kindergarten as well. So I had 2 years ago said I want to be on leave in fall 2024 so I can do all of the public facing stuff that I do during the election that takes up so much time. And so I had that plan. Well, this is just a little inside baseball about the law school, what's going on at the law school at Kentucky. But our prior dean, Mary Davis, who is awesome, announced back in October that she was stepping down as dean, which is sort of a routine thing. So we did a dean search. The dean search failed to hire somebody. So one of my colleagues, Paul Salamanca, became the acting dean. And Paul was on the schedule to teach 3 classes, and he couldn't teach 3 classes and be dean. And so he asked me if I'd be willing to pick up one of his classes, and he and I teach a lot of the same stuff, including constitutional law. So I have 68 students in my con law class. There's just not room for me to also teach election law and do all of the various other public stuff like these sorts of talks at the same time. So that's probably way more than you wanted to know about internal workings of the law school at Kentucky, but I'm basically filling in for constitutional law when I wasn't supposed to be teaching at all this semester because we had the need to do it.
No, I have a long career in higher ed, and it's not just a law school thing. That happens all the time at universities.
Yeah.
My question, I know there's one in the chat too. My question is, we talk a lot about elevator speeches, like, be prepared to talk about an elevator speech about what the league does and what our work is. And I've been thinking about a good elevator speech for people that ask about the influence of the court in elections and, how to frame it in a way that's thoughtful and truthful and genuine, but and positive. So if somebody asked you, what's your elevator speech about the role the court plays in an election, what would you say?
So I can give you one, but except for the last word you said, it was "and positive." An elevator speech about the influence of the Supreme Court on voting elections is not positive. Now, I have a positive spin about what we can do, and the conclusion to the book has a whole bunch of ideas for court reform, for voting reform measures, the grand election compromise, et cetera. But the elevator pitch on and sort of the elevator pitch about the book and about the influence of the court is that the U.S. Supreme Court used to protect the right to vote very strongly, considered it a fundamental right, and said that it looked very skeptically at laws that would infringe upon the right to vote. And instead, the balance of power has shifted, and now the court gives extreme deference to state legislatures, to politicians in their voting rules. And so while previously the court made it easier to strike down a law that would harm voters, now the court gives a lot of leeway, and there are lots of things that a legislature or state can say to support the voting laws that it passes, and the court essentially says, okay, we're not going to question you. So to me, that's not a positive story, because the last people I would trust to create the most fair voting rules are the incumbents whose entire goal is to get reelected. They have every incentive to try to rig the rules of the game in their favor. But unfortunately, that's what happened in case after case. And that's really the connective tissue that goes through all of the cases I discuss in the book, is extreme deference to state politicians in the voting rules that they pass.
Thank you. Thank you.
There's a question in the chat. Let me see. What about the most recent Supreme Court case regarding Arizona voting law? It was kind of okay, but not entirely. So I'm guessing you're talking about the 2021 case called Brnovich versus DNC. Am I right that that's the one that you wanted me to address? Who asked that question?
Yes.
Okay, so it's the Brnovich case. And that is one of the chapters in the book. I tell the story of the Brnovich case. And this is interesting in that there's a lot of dissension among Democrats as to whether it was even a good idea for this case to be brought to the Supreme Court at all because of the negative consequences that stemmed from it. So the two Arizona voting laws in question were a prohibition on delivering someone else's ballot. So sometimes it's referred to as ballot harvesting, sometimes it's referred to as ballot collection. It's used a lot in Native American communities, in particular in Arizona. So you have these reservations where they don't have great access to the mails. Arizona has pretty permissive vote by mail law. Anyone can get a vote by mail ballot without an excuse. You can be put on a permanent list. So if you ask to be put on the permanent absentee voter list, then you automatically get your ballot in all subsequent elections. But Arizona passed a law saying you're not allowed to have someone else deliver your ballot for you. The second law in question was what was referred to as the out-of-precinct voting law, which basically means that if you decide to vote in person and you show up to the polls and you're in the wrong place, but instead of leaving and going to the right place, you cast a provisional ballot instead. If it turns out you were at the wrong place all along, then your ballot doesn't count. So you went to the wrong location, you cast a provisional ballot because you thought you were in the right place, ballots tossed if you were wrong. So this law was challenged. Both these laws were challenged by the Democratic National Committee, sort of stemming from a nightmare scenario that happened in Phoenix during the primary, where there was lines until 5 in the morning. And I discussed in the beginning of the chapter kind of what happened on primary day and how it was really disenfranchising. And so the Democrats decided to sue Arizona to challenge various of the practices, including these two laws. And what they said was that the laws harm minority voters. So that has a discriminatory impact or discriminatory effect on particularly Latino voters and Native American voters. And so they sued under what's known as Section 2 of the Voting Rights Act. So the Voting Rights Act was enacted in 1965, updated a few times since then. And Section 2 basically says you can't have a law that has the effect of discrimination on the basis of race. And so the plaintiffs brought some evidence to show that the law prohibiting ballot collection and the out-of-precinct law had a disproportionate impact on minority voters. It was more often that minority voters were the ones using someone else to collect their ballot. More often that minority voters happen to be the ones that cast a ballot in the wrong precinct. The problem with the evidence, so the problem with the Democrats' case, is that they had some evidence, they had some studies, but the effects weren't that big. It was, it was a percentage point or so. The total population that voted incorrectly, went to the wrong precinct was, I forget the exact numbers, but like 2% of the population maybe voted with a provisional ballot and was in the wrong precinct. And then if you isolate just Latino voters, it was like 3%. So yes, there was a larger percentage, but it wasn't a stark number. But they sue, and they lose at the district court. The trial court, the judge writes a really thorough opinion. An Obama appointee writes a really thorough opinion as to why the Democrats didn't have good enough evidence of this discrimination. They go to the Ninth Circuit Court of Appeals. They lose there at the 3-judge panel. But then they decide to ask the entire Ninth Circuit, which is like 17 judges, to rehear the case, what's known as en banc, the entire Ninth Circuit. And they win there. The Ninth Circuit says, yeah, Section 2 of the Voting Rights Act says no discrimination on the basis of race. Here you've got a little bit of a difference. So we're going to strike these laws down as invalid under the Voting Rights Act. So then the state of Arizona appeals to the U.S. Supreme Court. And so there's a lot of dissension among people about the Democrats continuing to appeal this case after they've lost a couple times because of fear of what the Supreme Court would do. And that's exactly what happened. So a case gets to the U.S. Supreme Court, and instead of issuing a narrow decision that was similar to what the district court and the initial Ninth Circuit said, that's similar to saying, yeah, you have some evidence, but the evidence isn't that great. These laws don't cause that much discrimination. The court went way further in its ruling. And as I write in the book, Justice Sam Alito, who wrote the opinion, he made up the law. And I don't make that kind of a statement lightly, but I think Justice Alito literally made up the law. Because what he did was not just say, okay, you've got this case under Section 2, but we don't see much of a effect here, discriminatory effect. Instead, he said any plaintiff who wants to bring a lawsuit under this provision now has to satisfy what he calls 5 guideposts. What are the guideposts? He says things like, well, you don't just look at the law being challenged, you look at the entire election system. So yes, if you voted at the wrong precinct in person, your provisional ballot doesn't count. But look, Arizona makes it easy to vote by mail. So if we look at the entirety of the way people can vote in Arizona, it's not that, it's pretty easy in many other ways. So who cares if this one method that some people use discriminate, because you could have chosen another method. He also says, well, if a law has been around a really long time, and he points to 1982, which is the last time Congress amended the Voting Rights Act, Section 2. So if the law has been around since 1982, it's got a long pedigree, then who cares if it has some discriminatory effect today? So he makes up all of these so-called guideposts that come from nowhere. They come from nowhere in the statute, nowhere in the legislative history. They literally come from his brain, and says now these are new rules to that plaintiffs have to satisfy to win a case under Section 2 of the Voting Rights Act. So when you combine this with the previous case, Shelby County, which you may have heard of, which gutted Section 5, another provision of the Voting Rights Act, now you've got this case from Arizona, Brnovich, that in many ways guts Section 2 because it makes it so much harder for plaintiffs to make their case under Section 2 to show a law that is discriminatory, because you now have to satisfy Justice Alito's 5 guideposts that are literally made up. So, your comment, it's bad, but not that bad. I think the case is pretty darn bad because now it's this brand new test that makes it even harder for plaintiffs. That got a little technical, so hopefully you're able to follow everything. But there you have it.
It interests me because of the way they said, well, it's like 2% or it's 3%, and they address this small percentage, but it could become 4% or 5%.
Yeah. And
so
the court doesn't
what's
really say what
acceptable?
The court doesn't say what level of discrimination is acceptable. That's exactly right, which is sort of a weird statement to say that, like, well, some amount of discrimination is just okay we're just going to accept under the law, because you know what, those people, they shouldn't have wanted to vote in person. They should have gone and done a vote by mail or something like that, right? So, but the thing is, and I interviewed the lawyers who made the decision to keep appealing, and as one of the lawyers told me, he did 2 things. He said, one, look, I've got a client, and my clients wanted to press the case, and so I had to keep pressing the case because that's what the clients wanted. The other thing is that the Supreme Court was not as bad in terms of its makeup as the case was going through the system, right? It takes a while to go. And so in some ways they were kind of surprised that, well, the train had already left the station, that this was moving, and now the Congress composition changed. And maybe, he didn't say this explicitly, but kind of the underlying tone is like, well, maybe we would have made a different decision of going to the Supreme Court at all. At the same time, it's like, there's an interesting conversation going on. The court's been so bad. Should we just try to avoid the court altogether? And if we're doing that because we're afraid of the worst precedent that's going to be set out, are we basically just letting discrimination fester? And we're saying, well, some level of discrimination is okay because we're fearful of what the court's going to do otherwise. I think it's a hard conversation, and there's no easy answers on the right strategic approach. All right, let me look at the chat here because we've got a couple more things. Kentucky's approach to voting access and security under the leadership of Mike Adams and where we stand. So I've been fortunate to be involved in a lot of the conversations with Secretary Adams in terms of the voter ID bill, in terms of the pandemic response, and including up until today in terms of not today literally, but conversations this year about how our elections are. And what I'd say is that we are improving in a really good direction. We're not quite there in terms of a great system of voting, but we're way better than we had been. And there's some objective measures of that. So there's something called the Democracy Index, which is basically a ranking of states and how well they run their elections. And it factors in a bunch of measurable things like voter turnout, like registration levels, a bunch of other sorts of measures of basically how well you run your elections. And when Secretary Adams took office, we were in the mid 40s of the states, so ranked, in the bottom 10. And we've steadily moved up year after year, or after each election cycle, we've steadily moved up. So I think, I haven't looked recently, but I think we're somewhere in the low 30s now in terms of the ranking of states. So that's great, right, that we've moved up. And why? Well, we've done things like we've instituted 3 days of early voting. I'd like more. I think the secretary would like more as well. I mean, he's gone on record and saying he doesn't think 3 is enough, but we've done that. We passed this voter ID bill, but it's of the most mild and lenient forms of an ID law that exist around the country. And I'm really proud of the work we've done, or we did, to get that law to have all of the various fail-safe mechanisms that it has. Things like, if you show up to the polls and you don't have an ID, you can sign an affidavit under penalty of perjury, but then vote a regular ballot as opposed to a provisional ballot. Many other states, most other states with these kind of laws, say that you have to vote a provisional ballot. With the allowance of student IDs counting, which was not in the initial version of the bill that we got in, and the elimination of a requirement that they have an expiration date, which many other states say your student ID or any ID has to be currently valid. We got that out. So I think the voter ID bill basically doesn't disenfranchise anyone except for those who think they can't vote because they don't have an ID, even though technically they could vote. So I think we're doing pretty well on that. What we're doing and then the other thing we've done very well is we've moved toward all paper ballots in almost all counties. Now, I don't know if we're 100% in paper ballots, but we're getting a lot closer. And in the post-election audit space, where we're doing a really good job of implementing a system of verified post-election audits in a way that's best practices around the country. We're not doing so well, and why our numbers will never improve up into the 20s or teens in terms of our ranking on the registration deadline of 29 days before an election. We are among the worst states there. And this is an area where it's really going to take the county clerks to agree to reduce that deadline, because the County Clerks Association is so powerful. And I think Adams is supportive of maybe not going to same day registration, although I would like that, but at least of lowering that deadline. But the county clerks have to agree to do it. We're not doing very well on the rules for absentee balloting. We did great in terms of creating this online portal to request an absentee ballot, which is also a security measure because it allows the state to track the ballot through the system. But you still technically have to provide an excuse, and that really reduces the number of people who vote by mail. And we see in other states, if you look at the states with the highest turnout, the two things that are most common that they have are same-day voter registration and universal vote by mail. And we have neither of those. So we're doing better, but than we were, but not as well as I think we could be doing. Okay. Bridget, did I answer all your question or anything I can follow up with? We're good? Okay. The other Josh asked my take on the general signals coming out of SCOTUS regarding how it might treat election disputes in 2024. Well, I mean, I think there's no signals that we have in terms of official rules, because the court is only going to decide a case that reaches it. And we actually haven't had a ton of election disputes go to the court, except for most recently the ruling from Arizona on this voter registration issue. So Arizona has a rule that you have to provide proof of citizenship to be validly registered, at least for state elections. And there's a long litigation history about these rules, as proof of citizenship rules for registration. But the short of it is that Arizona now has a dual track system. So if you use the federal form, you're registered only for federal elections, that is Congress or president. If you use the state form, you have to have a proof of citizenship to go along with it, and then you can be registered for all elections in the state and federal. So use the federal form, you don't provide your proof of citizenship, you're in the federal only list. If you use the state form and you do provide the proof of citizenship, then you're on the list of all for all elections. A sort of emergency dispute about this went up to the Supreme Court, and they basically, and this just happened a week or two ago, they let the law go into effect. And it's going to cause, it already is causing a lot of chaos and confusion in the state because people don't know, well, can I vote in all elections? Can I only vote in the presidential election and the congressional elections? So the signal there is we're going to defer to the state. So I think what the Arizona court was very consistent with what I've talked about with respect to deference to states. The harder question is what's going to happen if there's a post-election dispute, and how would the court handle that? You know, I saw Ketanji Brown Jackson just the other day in an interview saying, of course we're ready, you know, for that, and we're going to rule consistently with whatever the law requires. And we've seen some other statements from justices like that. I will say that even though I have criticized the court in this book a lot about the way it is construed voting rights, it was good in the post-2020 election landscape in not allowing any of the crazy lawsuits from Trump and Trump supporters to win the day. So I do think there's a limit to what the court is willing to do with respect to not totally undermining democracy directly. They're doing it indirectly, in my view, through a lot of these rulings that defers to the states. But when they're faced with something that is, really just overturning an election, I think the court cares enough about its institutional role in the government that it's not going to simply overturn an election result or allow that to occur. Okay, Cindy asked, talking about the last chapter, elaborate on the proposal to put term limits on Supreme Court judges. Sure. So the last chapter of my book, The Court versus the Voters, the conclusion, has a number of reforms, and some of it has to do with reforming the Supreme Court overall. Now, I do think the Supreme Court needs reform. I think we need to have ethics rules that applies to the Supreme Court, just like they apply to the lower federal court judges. I'm not a fan of court packing in the sense that you sometimes hear, mostly now, Democrats talk about court packing. And the idea that, well, Republicans stole some seats on the court. They didn't let, Mitch McConnell didn't let Merrick Garland get a hearing. But then Trump was able to put in, Gorsuch and Brett Kavanaugh. And then right before the 2020 election, McConnell reversed course and said, we're going to push through Amy Coney Barrett. And so there's at least 2 or 3 seats that some Democrats say were so-called stolen. And so their solution is to add seats to the court to kind of even the balance. I'm not a supporter of that because that sounds to me like a political tit for tat that with no end game. It's almost like 2 wrongs don't make a right. And so, okay, Democrats add 5 members now, and then when the Republicans take over, they add 4 or 5 members, and then Democrats do it again. It just goes back and forth. So I don't think that's a long-term solution. I think there needs to be institutional changes on the long term, something that gets implemented over this course of several decades. And one of them is term limits. Joe Biden came out in favor of this just a couple weeks ago. And maybe I like to think maybe he read my book, but probably not. This is something that court reformers have been discussing for a while now, where each justice is appointed for 18 years. Why 18? That's long enough that you can make a career of it, but it's short enough that you don't become so entrenched that you don't have, that you're on the court for decades upon decades. And also, with 9 justices and 18-year term limits, that gives every president 1 appointment every 2 years. So every president in a 4-year term gets 2 new justices. So this would provide a regular rotation of justices on the court. It would hopefully mean that each nomination battle is not a fight to the end, a fight to death, which basically what we have right now is that each nomination is life or death, literally, on various sorts of issues. So if we we knew, okay, well, we got another appointment in 2 years, then hopefully that would lower the temperature of the nomination fight. It's not going to eliminate it entirely. You're never going to get politics out of this, but maybe it would lower the temperature of the battle. The other ideas in the book, which I don't hear talked about as much, but maybe Joe Biden should read my book, is on the lower federal courts, you have judges do what's called sit by designation. So a federal district court, a trial judge, will become an appeals court judge for a month. An appeals court judge will go sit and be a trial court judge. And that really helps them when they go back to their home court, and helps them understand the workings of those courts. I don't see why we don't do that with the Supreme Court as well. There's nothing magical about the justices, except for we declared them to be magical. So I think we should have a more regular rotation of who sits on the court, and let some judges sit by designation, randomly drawn. Hopefully that would help alleviate this idea that we know the outcome is going to be a 5-4 or 6-3 ideological decision, and the focus would be more on the law itself. I also think that perhaps we could copy the appeals court judges and have panels. Justices sit on randomly selected panels, where again they have to focus more on the law and the precedent, as opposed to what Justice Alito did and made up the law in that Arizona case. So those are various ideas. The term limits one is the one that's gotten the most traction, of course. And I think it'd be a long-term fix. There's some questions about whether it'd be constitutional or not. Nothing in the Constitution says that you can't impose term limits so long as the justices get to keep their title and their salary as judges, essentially, which already happens. When a justice retires, they become a senior justice and they don't hear cases. So we could require that, I think, under the Constitution. Okay. Next up, since we have 3 days of early voting, you can go anywhere to vote. I'll tell you about that in just a minute. Is there any chance it wouldn't matter where you go vote in this technology time sometime in the future? So a couple things. One, that's probably the thing I'm most proud of about my first book, Vote for Us, is that the idea for vote centers came in that book, and Secretary Adams read the book while he was campaigning. That was the year it came out. And he read the book and he contacted me and he said, hey, there's some stuff in this book I disagree with, but some things I think are great ideas I never heard of. And vote centers are one of them. Do you think we can implement them in Kentucky? And that started a conversation about how to get vote centers in Kentucky. So I'm really proud of the fact that my scholarship had a real world actual impact on our state, because vote centers, as Mike will tell you, the idea started from my book. So the question though is, are we going to get to a point where you can go anywhere? So currently you can go anywhere in the county, right? I could envision a scenario where you could go anywhere in the state maybe, but it gets a little more complicated because of what's known as ballot faces. So if you think about when you vote, your ballot faces all the offices that you're eligible to vote for, and that includes president and member of Congress and the local mayor, but it also includes things like your local water board person, or your local school board person, or your local state representative, your city council member, all on the same ballot. And so like in Fayette County, in Lexington, there's probably something like, in each vote center, there's probably something like 150 ballot faces. I don't know the exact number. We'd have to ask Susan Lamb. But there's a ton of ballot faces. That is different variations of what the ballot could look like. And so in the vote centers, they're printed on demand, right? That gets even a lot more complicated the larger geographic area we're talking about. And so it's just a logistical issue of how do you make that happen. That said, there are a few places in the country that are allowing some internet voting through an app. The app is called Vote, V-O-A-T-Z. I actually interviewed the CEO of that company for the Democracy Optimist podcast. So if you're interested in learning more, you can listen to that episode. And there's a couple places in West Virginia, a couple places in Colorado that have used it for like military or overseas voters. And it uses the blockchain. So it's pretty interesting. I don't think that most technology experts will say that we're not quite there in terms of technology, but Estonia, the country of Estonia, does internet voting and seems to work pretty well there. I'm hoping to do some more research on how it all works there. So I'm really proud of the fact that we have vote centers. Whether we can get a larger geographic area is just the logistics of it are really complicated. Again, this is another area where it's really important to get the county clerks as part of the conversation. And maybe internet voting someday, but not anytime soon, I don't think. Okay, searching for the Democracy Index. It's MIT, I think. So the Democracy Index was the name of Heather Gerken's book. She's a professor, became dean of Yale Law School. And the initial idea of the ranking and how to do the ranking was called the Democracy Index, and that's her book. But then MIT took it on themselves to actually create it. I think they call it the Election Performance Index. So if you Google Election Performance Index, you might be able to find it there. Tip asks, so there's two sets of ballots in Arizona. Yeah, you get the federal only ballot, or you get the entire ballot, depending on what your voter file says. A total logistical nightmare. And it's a major problem for elections. I don't know if Tip is still here, but hopefully you can get that answer. All right, let me just keep reading the chat here. As I understand it, one can sign a petition to have a candidate's name on the ballot, even if you're not promising to vote for that candidate. That's correct. You so you cannot sign a second petition for another candidate. I think that's right under Kentucky law. Each state's law is different on the nominating and petition process. I think that's an accurate statement of Kentucky law, which is why when you are running for office, you're getting petitions, you always get many, many more than the requirement under the law, because of the chance that some of them will get thrown out. And that's happened. And there have been candidates who have been tossed off the ballot because they don't have enough signatures. Like there's a candidate for Lexington City Council a few years ago that this happened to and didn't get to run. And I'm friends with him. I sort of joked with him that he became a topic in my election law class because he admits, he's like, I screwed up. I just got just a little bit over the number needed, and a bunch of them got thrown out, challenged and thrown out. So you always get almost double what you need. Okay. Civic health assessment that Adams published, Health and Democracy Index. I don't know if that link is I think now we have it, the MIT Election Performance Index. So there's your link to find it. And I haven't looked recently, so I don't remember what Kentucky ranks after the last election, but I think it's 30 something. Someone can take a look if you want. Additional voting days and voting centers haven't seemed to move the needle on voter participation. I dispute that notion, in that we don't know yet if it's moved the needle on voter participation. These things take a while to see the downstream effects of them. So early voting and vote centers are new. We introduced them, the vote centers, just during the pandemic election. It takes a while for people to get used to this sort of thing. I think the jury's out on whether they have an effect. Also, measuring turnout is really hard to do in terms of a causal effect. There's so many different things that drive turnout. The quality of the candidates. We had in 2022, I think we didn't really have what many people considered any majorly competitive elections in the state of Kentucky. So it's hard to say what the actual effects are, or whether there's a causal connection there. So what's the answer to getting more people to vote? It's all of the above that we're talking about. I think expanding early voting a little bit, but certainly the registration deadline is really important. Civics education, like the League is doing, like groups like Civic Lex are doing, is key. I think, so better civic education. But what I do is I look at the states that have the highest turnout numbers. Places like Colorado, places like Minnesota. And what are they doing? They're doing same-day voter registration, no excuse absentee balloting. The states that are doing this the best automatically mail you a ballot without you requesting it. Some people are concerned about fraud. I think, getting an automatic mailing of your ballot, a true universal vote by mail, is unlikely to happen in Kentucky anytime soon for politically. But, look at states like Oregon that do it and do it really well. They don't have voter fraud. They hire forensic experts in handwriting to compare signatures. So they actually they hire the forensic experts to train their election workers on signature matching. So we actually can ferret out potential fraud even more easily. So it's all of these things. So it's little by little, but I don't think we can look at one election cycle and say, well, it didn't work. Talk to me in 10 years, and we'll see whether some of these things potentially had an effect. All right, someone linked to the election form. What number is Kentucky on end of the 2022 list? Anyone take a look? I just don't remember off the top of my head. Suppose I can click on the link.
We're like halfway down.
So we're like in the low 30s, right?
I think so. Actually, my screen won't work now. I can't.
You look at the overall ranking. Here we go. The ranking
Looks
So
like we've gone from
37
yeah.
in
Okay.
2022. 2020, we're 32. So we went down a little bit in the midterm. But if you look at, let's say I'm just looking at random 2012, we're at 39. We have moved up. If you look at let's see. Let me see. In 2016, we were 43, right? So we've slowly started to move up. And I think hopefully more of that is going to happen. All right, let me go back to here. Brought up Estonia. How many Western European countries disenfranchise citizens for criminal convictions? I don't have an exact number for you. The US is certainly the worst, but part of the problem is the things that count as felonies that are disenfranchising are way more numerous than in other countries. It's a complicated question because of you're not comparing apples to apples on Western democracies and the sorts of things that lead to felon disenfranchisement. And also, it varies based on states. So some states like Maine and Vermont never disenfranchise anybody, and you can vote from jail. We can vote from prison. We absentee ballot, Maine, Vermont, DC. Other states like Virginia and Florida and Kentucky, the law in the books is that you're disenfranchised for life unless you get a federal, or excuse me, I guess a gubernatorial, not pardon, but giving your rights back. In Kentucky here, that's obviously Andy Beshear has been doing that. We're not doing a good enough job in the state. The government's not doing a good enough job of educating people that they have had their rights restored. I'm pretty disappointed by the Kentucky cabinet in the lack of, I think, outreach that it's done to various communities to let people know that their rights have been restored. So the state laws vary a lot as well. All right, I think I've gotten through all the things in the chat, although someone tell me if I missed anything.
I added a question asking about vote centers because we noticed that some of these rural counties only have one vote center, and it actually is having the opposite effect in that it's limiting access because they're geographically large places, which may not have a huge population. And then the county clerks are like, yeah, I'll just have one place in the middle. And so how can we help, make it more accessible and keep county clerks from kind of distorting the intention of having a vote center, which is really to help more access and have multiple vote centers.
So one of the things that the State Board of Elections did was they made it a requirement that they have to approve all plans for vote centers. Previously, the county clerks would just do it. And now the State Board of Elections needs to approve. So, part of it is, I think, educating the state board on the dynamics of the various localities and what is needed there. And so I think, we can do more to reach out. I think perhaps there's not enough public outreach to the members of the State Board of Elections on various issues like this. And since they are the ones, along with the Secretary of State, that ultimately gets to approve these various plans, I think we could do more on that front. And the other thing is, we could, and there were some conversations about this, and perhaps these conversations should be started again, about a state law that has certain thresholds. Your population is X size, or maybe your geographic area is a certain amount of square miles, then you need a vote center in one vote center per X number of square miles or something. I mean, we could come up with a formula that is in state law as well. And that could be something that, could get bipartisan support if we had some sort of metrics or rules. So I think that'd be a worthwhile conversation with the secretary as well, is if we are seeing that kind of problem in various counties, whether we could implement some rules that dictate rules, the guideline, either guidelines for the state board of elections or even state law that says here are the number of vote centers you need per population or per geographic area.
Idea.
Well, thank you so much for your time. I'm noticing we've had such a dynamic discussion that we've gone a little bit over, but thank you so much, Professor Douglas, for sharing your expertise and these fascinating case stories tonight. And we appreciate the work that you do to make this subject of voting and elections approachable, and for piecing together how the Supreme Court decisions are affecting our voting rights. And so I put in the chat, if you want to purchase this book, it's on Amazon.
And can I put a quick plug in for anyone who has read it and enjoyed it? This is total self-promotion, but if you've enjoyed it and you wouldn't mind putting up a review on Amazon or Goodreads, that always helps. I've only got, I think, 5 reviews right now on Amazon. They're all 5 stars, so I'm proud of that. But my first book has something like 60-something reviews. So we need to up the numbers on Amazon. So if you've enjoyed the book, I'd love a review. If you hated the book, just send me an angry email.
And speaking of elections, you all may know, but the voter registration deadline is October 7th. We have specialized voting information for Kentuckians at vote411.org. And we have a special white label /LWV KY, and so that will have a registration link directly to the Secretary of State's portal. But I also have a little bit closer to the election, there will be a voter guide there with our nonpartisan voter guide, and there's also lots of opportunities to get involved with direct voter outreach throughout this election cycle, with nonpartisan canvassing, virtual voter outreach, texting parties, voter registration events, candidate forums, Vote 411. We still need some more volunteers with that, and more. And but one of the most powerful things that you can do right now is to reach out to your friends and family and acquaintances to remind them to register to vote. That is the #1 most powerful way to do it. I know we all think that our friends and family, that they're, they check their voter registration and they vote, but they may not. And they may not vote all the way down the ballot. And so those things are super important. And a great way to do that, some of you may be on our League in Action platform, but that is a great way to kind of find out about volunteer opportunities that are coming up, and also gives you opportunities to kind of make it easier to do that direct voter contact and reach out to your friends and family, because you may not know where the deadlines are. You have to look it up. We pre-write all that stuff for you, make it super easy. And we also send you election reminders through app notifications. So be sure to turn on app notifications. You don't have to be a League member to be on it. So that's a tool that you can also, like, for people who, Kentucky election deadlines are kind of confusing. And so it's like an easy way for people to just, like, it just pops up on their phone and like, oh, hey, I need to request my absentee ballot before tomorrow. And then I'm just going to drop a link in here for you can give us some feedback about how you thought, if you like this this webinar that we had today. There's a link in the chat for a feedback form. So thank you so much. Thank you, everyone. Thank you again, Professor Douglas. We really appreciate it. And everyone, have a good